As of the time of this broadcast, I cannot dispute the cognizant fact that issues that are governed by books and that do not require any scientific approval, anyone can be. And that is why up to date, anybody can read the Bible and be called a pastor. Anybody can read the Constitution and be called a lawyer. And in fact, we all know people like Oscar Sudi and the current Nairobi governor, to whom failed to produce their certifications when the Electoral Commission requested for them.
I will obedient this truly, this obey of unfaithful public of consensus or senseless. I will say, Ewe Mungu unisalimie.
What I'm simply trying to mean is competence overrides protocol. And in the last 1 week, the name Brian Mwenda has been a subject of discussion in the public purview. And in this episode, I'll just like us to outline only the nitty-gritties as to why this man, Brian Mwenda, the quack lawyer, could be innocent.
Your Honor, my name is Brian Mwenda. Brian Mwenda. I'm on record. I would like to bring the court to the attention of the affidavit, the supporting affidavit of CIP Kemboi, Rob. And I go straight to number 4. It indicates paragraph 4. He says that on the 20th of July 2023, the 3 accused persons were arrested at Kiserian. I would like to correct, I would like to indicate to have the court note that that is incorrect. Our clients were arrested on 19th. So this...
Your Honor, sorry to interject. We respect that information, but counsel cannot say it from the bar. He should have an affidavit stating what he's saying. Those are matters of fact. And we respect him where he says that, but he cannot. The rules of
Your
the
Honor,
game
they've only served us with the application, so it is only fair that we mention it. Because if they are presenting something verbally and it's contradictory to what is on the affidavit, which I was going also to highlight, there are quite a number of facts that are not in alignment. So it is not good practice, and it is not in the interest of justice that we allow that to decline to listen here. During the application, they were referring to the same affidavit. They were referring, the colleague that before the meeting referred to the same affidavit, trying to tell the court that they should deny my client bail. This very affidavit, the CIP swears, I find paragraph number 12. He swears in support of the prosecutor's application to deny each of the respondents' bail. Verbally, they submitted that they are only opposing bail for the first respondent, for the first accused. So it demonstrates prejudice and abuse of the whole process, because why haven't they indicated why they've only changed their stand on the opposition of bail for only one individual in the same matter? I would also like to refer the court to paragraph 10, that being an influential person in the Republic of Kenya and a known leader of the outlawed Mwenda sect. Now, this is speculation because it has not been proven for any court before. And it is unheard of that in any jurisdiction in the world that anyone has ever been denied bail because they are influential, or your notability provides that because of how famous you might be or well-known you might be, you know, that negates or it diffuses your right to bail. I would also like to refer the court to the Criminal Procedure Code Act, Section 123, which stipulates very clearly 123, the Criminal Procedure Code Act, which stipulates the charges, the crimes that one will be charged for, and the possibility of getting bond will be lower. I'll have the court know that the charges presented before this court are not stipulated in that act. The act also gives this court jurisdiction and autonomy to give favorable and not excessive bond terms to all accused persons with respect to what I just mentioned up there, that what they are charged with is not included in the very exempt circumstances where people are denied. I'd also like to highlight to the court that in the same nature, that the first accused person is a very well-known person, and therefore he's not a flight risk. Why am I saying this? I'm saying this because if you're notable, it is incredibly difficult to. I'm just presenting an option. Let me proceed to the next point. There's a clause, there's a paragraph that indicates that he might intimidate the witnesses. I'll have the court know that the witness is a police officer who is armed. And the allegation on paragraph 8 that the client might cause harm, rather crucial harm to the witnesses, which I find very problematic because they're saying witnesses and the only witness that is indicated is one witness. So where is the evidence that this accused person is going to present, or rather might cause any danger or crucial harm to the witness who is an armed police officer? So I submit that if somebody alleges something, and I refer that to the Evidence Act, they must prove that indeed this individual poses a threat to the said witness. That is all.
Objecting to that it was relevant. The flight.
Yes. It was quite relevant.
And the resident.
Yeah.
Now, how was today?
No, today is okay because we have seen our client for the first time. This is what they should have done on Thursday. Because while hiding, there's no reason whatsoever. If you want to charge, the process should be open, transparent, and accountable. That's what the Constitution dictates. When they hide him, we suspect that they are doing illegal things. So, but you can see the team of lawyers who have defended him is a team of seasoned lawyers who are experienced and who have articulated the constitutional and legal principles properly, and we believe that any institution addressing its mind properly to the facts and the law will always admit them to bond.
But before we get into that, in case if you're watching me for the very first time, kindly just consider hitting on the subscribe button. If you've been watching my videos and you have not subscribed, kindly do consider hitting on the subscribe button. Now, I'm still wondering why our Kenyan lawyers seem to be very insecure with this one man, Brian Mwenda. Simply because we know as a matter of fact that outside here, there are some Form 4 leavers to whom have developed softwares that are being used by our learned colleagues. Essentially, also out here, we all know as a matter of fact, there are some Form 4 leavers to whom are constructing vehicles that are used in our day-to-day activities. If that is something we are to go by, does it mean that we should dispute their work simply because they do not have the required certifications? Who doesn't know that Bill Gates, being the father of software, at some point he dropped out of school? Before they calling Brian Mwenda a quack lawyer, they should first go for the perennial lawyer litigants to whom, since time immemorial, have never won any case, despite the fact that several clients pay large amounts of money to them only for them to fail them, not winning the case. What's the certification for if you cannot win any case? Out here, there are some computer scientists to whom are overqualified, and despite their qualification, they are using Bill Gates software. Why is it so? It is so simply because the competence of the software that Bill Gates created, despite the fact that he dropped out of school, overrides the protocol that he reframed. And which is this protocol in this case? The protocol is he refrained going through the system. And that is only if I'm not to mention of Mark Zuckerberg, the owner of Facebook. Back in 2021, a man was caught to have flown with the Kenya Airways as a pilot for 8 good years without certified licenses. Few years later, Mugo Wawerimu, the quack doctor, was caught to have treated patients for years without stepping into any medical school. And today here we are with the case of Brian Mwenda. If they've proven competent, why don't they let them be? Because I repeat, competence overrides protocol. If it is indeed true that this man, Brian Mwenda, won over 26 cases against certified lawyers, then I kid you not, this is the right time that the Law Society of Kenya should just recall him and issue him with the valid certifications if indeed it is true that he has no any of those certificates. Because the dream of any trained soldier is to test a battle. Here we are today with the case of Brian Mwenda, to whom has already tested 26 battles against certified lawyers, as it is so alleged. So my opinion is, if it is indeed true, then LSK should just recall him and issue him with the required certifications. But honestly, that has just been my opinion. If you do have a contrary opinion to mine, kindly feel free to drop them in the comment section and I'll give them a right of reply. And as I come to the penultimate part of this video, in case if you're watching me for the very first time, kindly just consider hitting on the subscribe button. If you have been watching my videos and you have not subscribed, kindly don't forget to click on the subscribe button. And as I come to the penultimate part of it, let me give you my word advice of the day. And the quote states that every criminal has a very good heart that is conquered by the devil. Thank you, and may God bless you.
Hi, good morning everyone. As promised over the weekend, that today we'll be producing our friend Mwenda to the relevant investigative agencies offices. We are waiting for IG Commerce direction on where to take him to record a statement. So right now, it's just a matter of confirmation from Mr. Kome. So this young man here is not a fugitive. He's a young Kenyan. Na in the future CJ of this country, future Attorney General of this country. Brian, you say something.
Good morning, everyone. As we promised over the weekend, that was on Friday.
Yes, it's Friday, even yesterday.
Yeah. Today, Monday, we had promised that I would go and record a statement. However, the DPP released a statement.
Yeah.
Requesting an investigation to be done by the Inspector General. So thus far, this is a declaration that for purposes of record, I am not a fugitive, and I am a law-abiding citizen, and I am not going anywhere. Any place that I'll be needed, I will go. We love the law, and we want to, persuade people. It's not just the text of the law, but the purpose of the law that also it should also count, so much as the text counts. The purpose should. Thank you.